distinction here primarily affects foreign-born individuals. So
Again, impact.
right, that's one. Next is that the New York State and New York City have issued orders, executive orders, directing its agencies to provide comprehensive language services. And NYPD is one of those agencies. Furthermore, the NYPD is required.
But that doesn't make it a constitutional.
Honor, if I may just key up one thing that was said, the last thing that was said, which is this idea of altering an argument. They faced a problem because the Salazar decision had come down from the appellate division. When they are at the appellate term, recognizing that it would be binding upon the appellate term, they say in their reply brief to this court, we were free to alter our argument. But they're not free to alter their argument. That's what's very disturbing about this case, because although the oral argument today focuses on one dimension, the brief does not. The brief proposes that this was an individual who speaks English to a degree, but the police were derelict in not determining that. That is a complete good friend, elementary Appeals 101 problem. There's an undeveloped record on this. We have absolutely no idea. I could say, as an officer of the court, that I have seen the IDTU tape in which Spanish was the language that was used for the refusal warnings. And that's a good indication for a highway officer if the person is relying upon the Spanish refusal tape. Also, in his statement to an assistant district attorney, he had a Spanish-speaking interpreter. So while this is an undeveloped record, and I think we really can't get into it, there's a sort of backstory in this appeal, which I think even merits its dismissal, because really you'd have to then razor out all of this and then just get to the pristine sort of Salazar question. And I don't think that, I mean, you could do it, but I think this is so freighted with other material that it's hard to ask what this court is supposed to do. Is it supposed to find that the Salazar rationale was correct or incorrect, or that a person who speaks English, but it's not adequately divined by the police, is at a disadvantage? That's an entirely different scenario, and it poses a different problem.
I'm sorry.
Yeah.
Judge Piggott? No.
Didn't they make due process and equal protection arguments in criminal court?
Yes, strictly as a non-English speaker, which,
Well, but my point is that
Yes.
they made the arguments that they're making here.
well, today, yes.
And I'm
but-
almost done. And then
Sorry.
when it got to the appellate term, up pops Salazar. But it's all still due process, equal protection. Salazar was in October.
These cases already existed. It's true the appellate division decision had not come down, but there was a raft of cases in Bronx County elsewhere.
Well, that's a
In
different
fact,
argument than you're making. You were saying that, after Salazar,
Yeah.
they changed all their arguments.
They're saying it. They're saying that they altered, it's in their brief at page 3. They're saying he's free to alter the emphasis of his argument, but he's not free to alter the emphasis of the
Well,
argument.
that's what I want to ask you about. And maybe we're just fencing over nonsense, because he's saying we're altering the emphasis of our argument. We're not saying it's not due.
He's saying that.
Okay. We're not saying it's not due process. We're not saying it's denial of equal protection. We're making those same arguments. We're changing the emphasis because
No.
Okay.
No, I disagree
mind.
totally, because the court...
I wanted to get a thought out. And
Yeah,
and I
well, I'll
thought
give
it
you a
was good
thought.
one,
Well, I hope it's a good one. That the Nisi Prius, well, you're the judge. I hope it's a good one. The Nisi Prius court said he's Spanish-speaking only, and that therefore said it was a violation of equal protection due process. Then when the Salazar case came down, in which it gave, I think, a very cogent ruling as to why language is not a suspect class, is not unduly burdening suspect class, because you have people who speak Greek, Russian, Latvian, not only Hispanic people.
Suppose
Yeah.
Salazar's wrongly decided. I'm not saying it is, but I think that's their argument. They're saying that when the appellate term made its decision, it felt bound by Salazar. Are they right about that?
But that's under the circumstance
They
that
right
it's a
about that?
non-English speaking
Are
person.
they right about that?
Well, but they're conflating
Their
it.
guess is yes.
But they're conflating it.
I understand that. Well, what I'm saying is, they're now arguing because the appellate term was bound by Salazar, and we think Salazar is wrongly decided because of our arguments on due
Right.
process and equal protection, we want to make these arguments.
You can't, because you can't say from the Nisi Prius court, he's Spanish-speaking only, and then on appeal says, look, he can speak English, and the police, as part of their dereliction, don't investigate and determine what defendants actually can speak. That's
So your
totally
arg-
different. It's 180 degrees.
Your argument is that, so what? So what if we violated our own rules? So what if we are treating Hispanics differently? The fact of the matter is that's not the argument that was before the court at the appellate term.
It's not justiciable.
Excuse me?
It's not justiciable.
So you're saying yes?
Yes,
That's-
it's
okay.
not justiciable. But if you wish me to get into the Salazar, which is the shred of argument that remains from the Nisi-Prius court, I would say that Your Honor's questions are highly indicative of the problems that there are in this case, because, as I said, you have language has been found not suspect because you're not burdening one group. Now, if it's a suspect group, such as Hispanics, it still has to be because of, not in spite of. And I should note this also, which maybe was not made
The
clear.
U.S. Supreme Court has, post-Soledad Perez and these other cases, said that under circumstances, for certain circumstances, for certain populations, language is a proxy for race or national origin.
Well-
Right, that was a New York case that went up to the Supreme Court.
But I-
Their argument is that this is that case.
Well, but it's not, because there's so
Why
many
not?
people. New York is a polyglot city, and I don't think what you'd be doing is shifting onto other racial, ethnic groups the burden of having to deal with this. If you say Hispanic people does touch on ethnicity or race, and so we must have that scrutiny. What's going to happen with the Chinese-speaking person? It's going to then shift onto that person, and they can, with
Well, I
impunity...
think the Supreme Court's ruling, or their statement at the end of that case, is that it depends on the nature of the case. But can I just go back
Yeah, sure.
to explore this, your point about the undeveloped record, because the record is quite thin in this case. Is the people's position that there was not an opportunity to really address these claims in the sense of establishing what is your rationale for this rule, and that indeed it is not unconstitutional?
No, we were not encumbered strictly in the Salazar argument. What we were encumbered, and we feel is completely, more than encumbered, we were completely denied, was the argument that was raised for the first time at the appellate term in response to our appeal, not his appeal, that a completely different scenario. We didn't have the opportunity to develop any record on that, nor did the court below.
Oh, about the defendant's actual language
Yes,
ability?
absolutely. There was no such. So
Well,
I can tell...
Counsel,
Yes.
what was the origin of that? Did the defendant put in an affidavit saying he didn't speak English, or
The
was that
attorney-
an affirmation by his counsel?
Yes.
What
The
was
attorney
it?
said he did not speak English, and Judge Adler, who is the Nisi-Prius judge, begins his decision with saying, defendant is Spanish-speaking only, and therefore he was denied his equal protection due process that would be afforded, let's say, an English speaker. But this is totally, that is one argument, but this case is freighted with other material, and I just wanted to bring that to the attention of the court, why this is such a problematic case, for what you're going to decide.
I'm sorry, what is this footnote, though, in the criminal court's decision? The people have not refuted the defendant's assertion that the failure to administer a physical coordination test was due solely to the fact that the defendant speaks only Spanish
Yes.
and not English.
Yes, that's right. That's exactly my point.
It says you didn't refute it. Are you saying?
Well, no, but this was not, refuted that he speak, we're not in the position to say his adequacy in speaking English. That's the defendant's argument. That's not our argument. They put forward the typical argument that was in Bronx County, that went up on Salazar, that he was not an English speaker, and that therefore equal protection because of language and the
But
burdening.
isn't there already something in the record? I mean, again, the record's a little bit difficult to get through, I agree. But
No, it's
don't you
not.
already have something that's like
No.
a full paragraph of what he says
No,
to
because
the officer?
No, because he's saying that we
Wait,
don't...
Well, what
wait.
language did he say that in? Or there's no way to know? Is it your position there's no way to know if that more than one paragraph that's quoted as what
Don't
he
know.
communicates
Don't know.
was in
And-
Spanish or English?
That's right, don't know. And second,
Do we know if the breathalyzer was done with an interpreter?
Spanish refusal.
Or was there an
Spanish.
interpreter involved?
They just said below, that's all. I mean, it just said below, which we're saying is not the same thing as the details that are in a coordination test. Because the point of a coordination test, let me just make this point if I may, it's not exculpatory. That goes to the due process aspect. It's to gather information, but it's really protective of a defendant in a way. Because I realize he blew a .06.
Why isn't it potentially useful to his defense, right? Because if he doesn't indeed show he's absolutely able to complete
Yeah.
this test,
Yeah. But what if he
Doesn't
is?
that give him something better than just his word against the police officer?
He could still say to the jury, I was never given that, I have .06, the people did not prove adequately.
That is not the same as
Well, all
actually
right.
succeeding on the
I understand
test.
your point, or your question, but the point I want to make is that where they do not give the test, they are in effect protecting, because if he stumbled because of language and he could not understand the highway officer, then you'd have a bad situation in which he has a .06, yet he has a terrible physical coordination test. So by not giving it to them, the police are actually in a way of protecting him. So that's why many reasons they don't give, just as Judge Abdus Salam was saying. Someone's hard of hearing. Someone may have physical impairment. Someone may be too drunk to take the test. But actually, which is sort of, and that they're falling down already. And so they don't give it
That
to them.
testimony will work against them, right? The
Well,
officer,
but
or whoever gives the test will say, it's too drunk as a skunk, I couldn't give this test. to
Well, the point is, they have to make a determination. Now, in this case, as I said, this is because it's a very thin record, that he had the breathalyzer refusal in Spanish. That would indicate to a highway officer, I don't want to give this test, he's not comfortable in English, and this is more complicated, it has a 30 or so complex things that have to be done in a sequence. The highway officer cannot delegate it to a surrogate, cannot do that, because he's the one, or she, is trained to do this, and that by giving it to someone who translates, the highway officer...
But did he ever make a claim below that, to criminal court, that indeed that process to properly identify whether or not the defendant was able to do this test in English was not followed, or there's not some protocol? Did he ever make that kind of argument?
I'm sorry, could you
I said,
please
did he
repeat?
make any argument
Yes.
that there is not in place
Right.
a protocol by which NYPD properly assesses whether or not a defendant can indeed complete these tests in English, even if they are a Spanish speaker or have some limited English ability?
Well, I think that there's always been, I'd have to look at it again, but there's always been a claim that these tests are unfair, could be performed, but the thing is, there is just no basis on this to determine what the real situation is. He can make any claim he wants, but if he is a Spanish speaker, he would need a highway officer trained in Spanish, just as a Chinese person would need a highway officer trained in Chinese or Greek.
Well, that's your argument. You didn't get to develop the record below, right?
But it was
To
not the
establish
tenor.
that.
It
What's
was
going to
not
be the basis for that?
It was not the tenor of the argument below. The tenor of the argument to the Nice Supreme Court was the typical argument that someone who does not speak English should be afforded translation services, should be afforded any measure in which to perform the test, and that it is violative by not doing it. That was the typical thing that had been raised by many defendants.
Thank you, Mr. Kaplan.
So, thank you.
Mr. Lishitz?
Thank you. Well, one point I want to bring up, and this is important. I do not know if Mr. Aviles spoke English sufficiently enough to perform a coordination test, but that's the point. The point of our argument, as part of the intentional discrimination claim under strict scrutiny, is that the police, the NYPD, does not have any protocol to determine whether or not a person speaks English sufficiently enough to perform a coordination
Well, in this
test.
case, counsel, as I read the record, allegedly your client responded to the officer initially in English about how many beers he had had within a certain period of time, and maybe a couple of other things in English as well. So are you saying that the officer could have made a determination that he spoke English sufficiently based on that to give him the test in English?
So the NYPD does not have any protocol to make a call. In our case, Mr. Aviles made a statement in English, and the officer still determined that there was a language barrier, but there's no specific protocol that the officer follows.
Do they have to have one?
They do, because that's part of the intentional discrimination claim. You have a city which is a quarter of the people do not speak English, and you have something like drunk driving, which happens every single day.
If they have a protocol, and I think they do, right? There's a protocol there.
There's an unwritten protocol which says they do not provide Sorry, there's no protocol to determine whether or not a person speaks
But if they
speaks
choose
English.
not to give the test, that's within their discretion, right, within the
That
police?
is within their discretion.
They don't have to give it at all, they can give it,
Exactly. So it invites profiling, and,
well, no, I mean, if it's raining out, if it's cold, or,
well, it's performed indoors.
no, it's not.
In New York, it is.
It's a lot of other counties. And if, I know you get stuck by that, but it's, so if they decide not to give it, it's okay. You can, as Mr. Kaplan points out, if the person, Salazar, apparently he was falling down drunk, so they didn't give him one.
Right. So
Okay.
in New York City, and we're talking about New York City's, New York Police Department's practice, not the practice of another police department, somewhere in Rochester, for example. We're talking about New York City. And in New York City, there are 6 facilities where a coordination test is performed.
So,
Thank you, sir.
I'm sorry, in the record...
more question.
I'm sorry. I just want to be clear, because you said this before. Is it you're conceding that that first paragraph, that first interaction, when he talks about hitting the car and the beers and all of that, he said that in English?
I do not know. I do not know 100%.
There's nothing in the record that indicates or
There's nothing in
clarifies
the record
that?
that
You never conceded that?
The briefs below had the statement. It didn't say whether or not the statement was made in English or in Spanish, but it seems that because it was written out in English, that it was made in English.
Thank you.
Thank you.